Welcome to Synergy's monthly Insight webinar series. This webinar is part of an ongoing series featuring one of Synergy's subject matter experts giving you thought leadership insights into issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says questions. If we don't have time for a live Q&A today, a Synergy subject matter expert will contact you to provide answers to your questions. Before starting today's webinar, the following is a brief presentation giving you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Welcome to today's webinar. My name is Jason Lazarus, Chief Executive Officer and founder of Synergy Settlement Services. Today's presentation is going to focus on lien resolution, outsourcing, and the ethical issues that accompany it. So there are two threshold questions that are necessary to ask, and how we're going to spend today's presentation is focusing on those two questions. One is why hire experts for lien resolution when you can do it yourself? And two, the ethical considerations in outsourcing lien resolution. As it relates to the first question, the problem for law firms is that they've got to track liens and sometimes have an affirmative duty to investigate and identify liens. Medicare, conditional payments, and Medicare Advantage plans are great examples of that. The law firm then has to determine whether a lien claim has merit and is legally valid. And then resolution requires law firms to interact with a variety of lien holders and recovery vendors. At settlement, there can be protracted negotiations to resolve the liens, ultimately resulting in disbursement to the client being delayed if negotiation isn't begun soon enough. In terms of the complexities and challenges in lien resolution, oftentimes in cases you're dealing with multiple different lien types in a single personal injury matter. You've got to keep up with the shifting legal landscape of lien resolution as it relates to all the different lien types. You've got to make sure you understand the legal obligations and potential personal liability of failing to resolve liens. Have to be able to identify standard reductions and available defenses or offsets, and determining applicable laws and recovery rights for non-government plans. So for the lawyer handling a personal injury case, there are a multitude of questions to answer related to each lien, such as what are the legal obligations and are you personally liable if you make a mistake? When looking at the client's net recovery, the question is, are they made whole and is full reimbursement to the lien holder proper? A threshold question, is there a lien? Is it a reimbursement obligation, just a debt? What standard reductions are provided by state or federal statutes for the applicable lien? What other reductions of a lien or reimbursement obligation may be available to the client, such as legal offenses, compromise waivers, or offsets? Is the reimbursement obligation owed limited to past payments, or does it also include future payments? Are there any state-specific laws peculiar to the jurisdiction that impact resolution? For non-government benefit plans, what law applies, state or federal? Is it governed by ERISA, FEBA, MICRA, or state law, combination of laws? Who is the plan administrator and recovery vendor for non-government plans? Can the plan or vendor actually prove it is the type of plan it claims to be and its recovery rights under the law? A lot of questions, a lot of issues to make sure that you're aware of. So the question becomes, does it make sense to partner with lien resolution experts? And my short answer would be most definitely. Partnering with a well-qualified lien resolution group minimizes a law firm's operating expenses. Every business wants to decrease operating costs, and increase efficiency. This can be accomplished by outsourcing all the time-consuming lien resolution functions. The large amount of time and effort typical personal injury law firm devotes to post-settlement lien resolution issues is, in most instances, creating a loss to the firm's bottom line. And outsourcing lien resolution functions allows the lawyer or firm to pass on the cost to the client in most states, similar to the cost of retaining an expert. And a trial lawyer's valuable time is better spent on moving cases towards settlement or trial and not cutting through government private health plan red tape. And the health insurance industry for decades has recognized these complexities and turned lien resolution over to recovery vendors themselves to make sure they get paid back after an injury is sustained by one of their members. Frequently, an attorney representing an injury victim is left to fight these vendors with one hand tied behind their back due to the lack of resources, time, and specialized knowledge. The recovery vendor's business model relies upon this to make it much more difficult than it needs to be for trial lawyers. They know it can be overwhelming, and they exploit that to their own advantage. So the first question to ask yourself is, do you want to take on large, well-funded recovery vendors or partner with a lien res group that has the requisite expertise to fight fire with fire? Lastly, the importance of an outstanding result for a lien can't be overstated. Getting outstanding results when it comes to lien resolution leaves the client, your client, the injury victim, with a positive, lasting impression at settlement. Clients who are not properly educated about lien resolution don't understand these obligations to lien holders and wind up having to pay back too much, which frustrates them and results in discontent. A client's poor impression post-settlement can affect your reputation and your law firm's reputation. So it's a lot of good reasons why to consider outsourcing. The importance of expertise in lien resolution is that issue spotting becomes very difficult for lawyers if you're not up to speed and understand all the nuances of law, and you may not have all of the most up-to-date and powerful negotiation strategies. And ultimately, as I just stated, ensuring the best possible outcome for the injury victim, client satisfaction, understanding of lien resolution, making sure that you protect the reputation of yourself and your firm, encouraging repeat business and boosting new client referrals. So when you're considering implementing a lien resolution partnership with a group like Synergy, you want to make sure that you integrate the lien resolution outsourcing early on in your case process. What I mean by that is making sure that your documents and your process facilitate working with a lien resolution partner. You want to make sure that you keep clients informed and educated about lien resolution, and then maintain regular communication with the lien resolution provider. And here, I want to give a little plug to Synergy's connection platform, which allows law firms to see in nearly real time what's going on with lien resolution matters outsourced to Synergy, which facilitates making sure that there is that regular flow of communication and information between the law firm and the lien resolution experts. In terms of the benefits of outsourcing for law firms, as I said, minimizing law firm operating expenses is a key benefit. You get to focus on what you do best by moving cases towards settlement or trial. You get a knowledgeable partner and a deep team of experts that can help throughout the entirety of the lien resolution process. Your firm can avoid inefficiencies and make sure that mistakes don't happen due to lack of expertise in the nuanced areas, for example, of ERISA or FEBA, and many other areas of lien resolution. And then ultimately helping to accelerate the lien resolution process by getting started earlier. Doesn't always result in a quicker turn time, but the better the coordination is between the law firm and a lien resolution group who are experts, that gets a better end result and better reductions. For injury victims, getting better resolution of liens and disbursement of their settlement proceeds is the primary benefit. Obviously, minimizing the amount paid back to lien holders is the key thing here to make sure that the client nets as much as they possibly can. And our team is dedicated to fighting as hard as they can to protect the net proceeds, but also giving injury victims the proper understanding of their lien resolution obligations and how a group like Synergy will ultimately make sure that the net to their selves and their family is maximized, making sure that the risk of post-settlement dissatisfaction is minimized and provide that positive lasting impression at settlement. So how do you go about evaluating lien resolution providers? Really, it boils down to looking at the team that you're going to be working with. How deep is their expertise in different lien types and laws across the country? So our team is second to none when it comes to that. We have a deep team of experts that understands these nuanced areas because nearly all of them worked on the other side for the recovery vendors, so they know the inside baseball. You want to take a look at track record and success rates, reduction rates, evaluating resources and capabilities, ensuring compatibility with your firm's needs and goals, and verifying, most importantly, a commitment to ethics and client satisfaction. So that leads me to the second question, is outsourcing ethical and permitted by the ethical rules? And the short answer to it is yes, but first let's talk about kind of the basics of ethical issues. So given the fact that trial lawyers focus on personal injury law, proving causation, liability, and damages, areas outside that scope may require you to work with experts because it's beyond the scope of your representation. And historically, personal injury law firms have sought the help of outside legal counsel, along with non-attorney specialists, to professionally and efficiently deal with a variety of complex issues that arise at settlement. Lien resolution is no different than when an attorney seeks the assistance of experts in other complex areas of the law that he or she may be unfamiliar with. For example, outsourcing occurs regularly when an attorney is faced with dealing with probate, guardianship, government benefit preservation, tax, bankruptcy situations that can and do often arise out of an underlying personal injury claim. Personal injury attorneys also frequently engage experts to help with accident reconstruction, valuation of economic damages, and Medicare experts. Subrogation experts are just one more type of expert that a personal injury lawyer can turn to that will enhance the bottom line net recovery while having a team to navigate the pitfalls commonly encountered during that resolution process. So lien resolution is an exceedingly complex area. It's extensive. There are different liens that can exist in the same case. Multiple liens can arise from one accident. Liability falls on trial lawyers ultimately to resolve these liens in accordance with state laws and regulations and federal law. Failing to pay a valid lien can expose clients to litigation and possibly loss of healthcare coverage. So outsourcing can be ethical and beneficial ultimately to the client for those reasons. Now, turning to the ethical rules. So ABA Model Rule 1.15 highlights the duty to protect third-party claims, and many state bar rules mirror 1.15. So a lawyer has to safeguard disputed funds and resolve liens effectively under these rules. And Model Rule 1.1 requires competence in areas that a lawyer undertakes, and in this instance, lien resolution. And inadequate expertise can jeopardize a client's interest and create professional liability. Outsourcing can ensure competence and protect clients ultimately. So ABA Formal Ethics Opinion 08-451, which deals generally with outsourcing, says that a lawyer can outsource legal or non-legal services As long as they maintain ultimate responsibility, there must be disclosure and informed consent from clients. Fees have to be reasonable and in compliance with the rules. The outsourcing lawyer must avoid assisting unauthorized practice of law, and direct supervisory authority must be exercised over outsourced providers. So there's several different states that have addressed head-on the ethics of outsourcing lien resolution. New York, Ohio, and Utah are some of the best at providing guidance. And I think New York's framework is a really good example of the way to address this if you decide to partner with a lien resolution expert, such as Synergy. So the New York framework example says that your retainer agreement with the client has to allow for outsourcing, and the client has to give informed consent to the arrangement. The fees ultimately charged must be reasonable and without surcharge from the law firm. Lien resolution must result in a net benefit for the client, so they have to net more money out. Outsourcing complies with state-specific bar rules and substantive law, and the referring attorney must maintain ultimate responsibility for the work. So if you're going to implement outsourcing in your practice, the question is, what do you do? Our recommendation would be to amend your fee contracts to include outsourcing provisions and make sure that ultimately the clients are provided with information about lien resolution outsourcing, and you secure informed consent. You want to ensure compliance with state-specific bar rules and substantive law, maintain a supervisory role over outsourced providers, and regularly assess and evaluate the effectiveness of the outsourced services. So best practices when outsourcing. You want to make sure that you're working with a group that maintains client confidentiality and data security. You want to make sure that you are working with a group that has the ability to effectively communicate between the parties. You need the ability to monitor the quality and timeliness of work, ultimately maintaining client trust and satisfaction, and balancing cost effectiveness with the quality of services provided. So in conclusion, outsourcing lien resolution is a viable option for trial lawyers, which can ultimately increase efficiency and results. Every second you spend on lien resolution is better spent on focusing what you do best, which is assisting personal injury victims recover the compensation they deserve. When you partner with a lien resolution provider, it benefits both you, your law firm, and the clients. You want to make sure you do ultimately ensure ethical compliance, and informed consent is critical as part of ethical addressing ethical issues with outsourcing. Having a strategic partner like Synergy with expertise in lien resolution is crucial to achieving the best outcome for the client. And implementing a robust lien resolution strategy with an outsourcing partner like Synergy enhances client satisfaction and ultimately firm reputation. So I wanted to end with a couple of points. One is, these are statistics on our resolution of different lien types. As you can see, we have saved injury victims in excess of $363 million since we began offering lien resolution services. We have incredibly high success rates with different lien types that typically will surpass what most law firms are able to get with these different lien types. So turning to an expert like Synergy will ultimately improve your client's net settlement proceeds when you compare what you're able to achieve versus what we are able to achieve. And lastly, I always like to end with the picture we take at our annual meeting. We've got a incredibly talented team whose sole focus is our mission of improving the lives of injury victims by protecting the net recovery, and then allowing trial lawyers to focus on what they do best. It's why our company and our team's been recognized as one of the fastest growing companies in the United States, because our partners, the law firms we work with, recognize how good this team really is at securing the best possible reductions for lien resolution matters. If you have any questions about today's presentation or want more information about outsourcing of lien resolution, we've got a white paper on this subject we can provide to you. Or if you'd like a copy of this presentation, feel free to email me or call me at the number here. We appreciate you taking the time out of your day to view today's presentation. If you'd like to learn more just about Synergy overall, visit us at synergysettlements.com or call us at 877-242-0222.